to kick this off. My name is Kat Trago. I'm the Wisconsin ACEDS president and for better or worse, the leader of our little Midwest ACEDS group. And we are thrilled to come back this year with another series, another 4-part series. And in this time, we are focusing on ESI protocols. That is a big topic of conversation right now. There's a lot of change and new technology in the industry. And so we thought that we would address that with a 4-part series. Today, we are going to start with Angela and Doug, just kind of sharing some of the, some of the stories from the trenches, essentially. They're both practicing attorneys and are well-versed in all of this. We're going to follow up with another series. I can talk about that at the end, but we're going to have another series where we get more into the brass tacks. That'll be April 18th, Modern Pitfalls to Consider. Then I believe David Horgan is going to moderate a judges panel for us on May 16th. And then finally on July 18th, we're going to have another working session and Kelly Twigger is going to help walk us through that. So really excited to have a great lineup once again this year. Thank you to everyone. Most importantly, I want to just shout out the Midwest chapters of Detroit, Ohio, Wisconsin, Chicago, and Denver. And today, Angela is joining us from the Detroit chapter, Doug from the Ohio chapter. And any questions, please jump in with any questions, put them in the chat. Abby Melling from the Detroit chapter is going to be monitoring that. And one final note is that we have CLE pending or applied for this session. Anybody who is interested in receiving CLE, we will follow up and ask for your bar information, and we will provide you with the materials for your submission. My apologies, I don't have that nailed down by today, but I will follow up. So look for an email from me, Kat Trago. I will follow up following the presentation. So without any further ado, I would like to kick this off with Angela and Doug. And I agreed to what?
All right. Thank you, Kat. My name is Angela Shapiro. As Kat mentioned, I am with the ACEDS Detroit chapter. I'm very happy to be here today. Doug, would you like to introduce yourself briefly?
Sure. I'm Doug Matthews. I'm a partner at the Voorhees Sater firm in Columbus, and I'm a member of the Ohio ACEDS chapter.
So we've been asked to talk to you guys about knowing what you agree to, kind of a big picture overview of ESI protocols today, the considerations that will go into them from a big picture perspective. As Kat mentioned, we have upcoming sessions that are going to go deeper into some of these issues. Modern pitfalls to consider. We will hit on some of those modern pitfalls today to put them on your radar. But to dive in deeper, please join us on April 18th for the team that will be discussing modern pitfalls. Of course, the judges panel. We love hearing judges' perspectives on these issues. So that's May 16th. And then July 18th is, Kat mentioned this, the working session that eDiscovery Assistant will be leading. And that is a session I personally am very much looking forward to. That will get into the nuts and bolts of actually putting all of this that we're discussing into action. So we hope to see you rejoin us as the series continues with the wonderful panelists to come. And with that, we'll dive right in. Doug, I'll turn it over to you to talk about what is an ESI protocol for those who don't have one to dust off.
So what an ESI protocol is supposed to be, if you do it right, is an attempt to get the parties on the same page from the beginning as to how you're going to handle all aspects of e-discovery to get as much as you can agree to up front and a clear process for resolving disputes down the road. So to try to avoid big, large, expensive fights and hindsight arguments at the end after you've produced. So that's the goal of it. It's really, the ideas are all encompassed in the various federal rules set forth on the slide, even starting with Rule 1 that that everything in the civil rules should be interpreted to secure the just, speedy, and inexpensive determination of every action.
Relatively.
Relatively, and sometimes ignored by courts and parties alike. But as you know, Rule 16 is sort of getting you ready for the conference, discovery conference and scheduling. Rule 26 obviously guides discovery, and then you've got your document production, Rule 34, and the where you really don't want to be is the Rule 37 sanctions part. But those all are frameworks from which you have to be within the bounds of to do your ESI protocol. And the idea when you're doing one is you want to balance sort of cooperation with the party, but you don't want to like give away too much. And it really, the factors that go into that and how detailed an ESI protocol you want are, you know, how much ESI am I going to have to produce? How much does the other side have? If you both have a lot, sometimes there's a mutually assured destruction fear makes you be very reasonable in your requirements, where if it's a one-sided situation, then one party might tend to be more aggressive or unreasonable depending on your point of view. You also need to consider, what are my opponents likely going to want from me, and what do I want from my opponent? Because I don't want to go totally bare bones if it's going to hurt me on what I receive. And in some cases, when you're on the smaller ones, you really sort of end up considering, all right, what can the other side realistically do? But those are all the elements that really go into the framework by which you're going to, how detailed am I going to be, how onerous are my requirements, are all weighed by those factors. The ESI protocol will deal with things like sometimes the preservation, collection, processing, review, and production. Sometimes people try to put other things in there. I think Angela and I will agree on most of the time those belong somewhere else. Sometimes it'll get built into a protective order. Sometimes it will include like the clawback provisions for inadvertent production. Sometimes it will include things about the privilege log. And I think we like to keep the ESI protocol separate from those. Sometimes an ESI protocol is simply just doing the production specs. But in most cases, you may want to include more than that in there, which we'll talk about.
So I do want to kind of riff off of what you were saying there at the end with the different types of orders that are out there, or different types of agreements even that are out there that some people consider to be part of an ESI protocol, or think should be a part of an ESI protocol. And I just want to distinguish quickly between most discovery orders and an ESI protocol. When you're talking about the substance of what's going to happen in discovery, substantive questions, that does not, in my opinion, belong in an ESI protocol. When you are talking about how to get your ESI handled in a way that both sides are agreeable with, and that is hopefully consistent with what you've already done by way of preservation for your client, and consistent with what you actually need from the other side, so that you're not losing sight of the goal. That is an ESI protocol. You will not find ESI protocol as a requirement in the court rules by that name. And you will find, in fact, that some courts and some practitioners use different names for it. But it has become a standard part of practice, particularly in federal courts, but also in some state courts. Some courts will even have a model ESI protocol. You should always check your jurisdiction first to see if there is such a thing to begin working from there. But despite the fact that we cannot point to a rule that says ESI protocol, you will find that it is an expected part of most modern litigation matters. So when do you start talking with the other side about an ESI protocol? Because this is a product that both sides are going to sign off on, whether it be it live as an agreement or it is entered as an order. As soon as you have the case, really, you should at least start preparing for the initial negotiations. And you really want to go into your Rule 16 conference already having a really good understanding of what you would like to see from an ESI protocol, if not already starting those discussions with opposing counsel. That can depend on your relationship with opposing counsel, the size of the case, the number of parties and counsel involved, all of those things. But what you don't want to do is put it off until, you know, after the Rule 26 subconference. You don't want to be caught flat-footed, because you're going to see throughout this presentation, there are extreme risks to rushing into any part of an ESI protocol and agreeing to it. You need to know first that you can live up to it on your end. And that's going to take some time. That's going to take understanding your client's data, the tools that you have available to you, what steps have been taken to date on preservation. So don't put that off till the end. Start your work immediately when you're brought in, and then start negotiations as soon as you have enough of a handle to really do that. It can take a long time. I mean, I'm involved, I don't know, there's cases where it takes months and months to reach agreement on all of the pieces and all of the terms. And I mean, we see ESI protocols that can range from a 2-page simple uh, specifications for the format of what is going to be produced, all the way up to 50-page documents that really dive into almost micromanage. Well, maybe not almost. I think in some cases it is micromanaging what the other side's doing for discovery. So that's all going to take time to negotiate and get on the same page with. So why don't we talk, Doug, about some of the big picture categories that people should at least have on their radar to consider whether or not it belongs in their ESI protocol.
Sure. And we're going to go through a number of different categories of things you should at least consider putting in an ESI protocol. They're not to say that they all need to be in there every time, and it really is on a case-by-case basis. But there are some protocols out there that will sort of discuss, all right, what sources of information are going to be covered by this or are going to be subject to discovery. So breaking them down, a lot of times it has to do with the documents you collect from that are individual to a particular custodian, their email, their personnel file shares, their local drives, their text messages, chats, things that the custodian can help you identify where they are and collect. But there also then will be non-custodial shares that you may want to treat differently than the custodian ones, where you've got group file shares. There may be, for the custodial searches, you may be using search terms or a TAR process to identify, technology assisted review, to identify what you're going to review. Where there may be other areas where the responsive documents, they're in a particular folder. You don't need to have search terms or anything like that. You know that if you ask the right people, they'll tell you, oh yeah, all of our agreements with the other side are in this folder here on this share file. You may want to treat those differently. So in addition to sort of group file shares that may include like databases that have relevant information that may require a totally different treatment. Document management systems, again, various ways where they're not a person's individual related documents, but the whole organizations that you're going to want to treat differently as a source. And how do you go about identifying them in discovery? And third parties, really where you're talking about you have data that you control, but it's not within it's stored off-site at a third party. But if you control it, then that may be part of what needs to be produced. So there are ESI protocols that discuss how those are going to be handled and shared and disclosed with the other side.
I'll add, when you're talking about third parties, you may want to also, if there are any, you expect that there may be any disputes about whether data in a third party's or hosted with a third party is in your possession, custody, or control. This may be the time to have that discussion with opposing counsel as well. Something to keep in mind. You'll note that a lot of the areas Doug was just talking about, I mean, they overlap, right, with your preservation efforts that you're making with or without an ESI protocol. So it's going to be important that when you get to the point of putting this into an agreement or reaching agreement, that you are reaching back to those early preservation efforts and making sure that what you're agreeing to on these points matches with what you have already done and are able to do for preservation. We'll see a case in a bit that that shows the dangers of not doing that.
So, so preservation and collection. A lot of times it's a very good idea to include some of these items in your protocol. Because the one thing you don't want to, you want to try to avoid a hindsight, oh, you should have preserved this, and you didn't when it's too late to do anything about it. So one of the typical things that I've seen in there, most cases do not involve having to go and look through inaccessible formats. I know when we first rolled out the ESI rules, there were vendors that would come in and say, oh, you need to forensically image every computer in your organization if you're in a lawsuit. And I was like, well, wait a minute. Most of the time, the active files that are out there that people can access on a normal day-to-day basis are the ones in 95% of the cases or more. That's all you need. And it's only in certain cases do you really need to get into the forensic examination. So, yeah, everyone may have responsive information that's in the Slack space on a computer that would require forensic treatment, or going to backup tapes. So a lot of the times an ESI protocol will say, hey, you don't need to preserve and collect anything that are part of those backup tapes, the non-active files. That's just not proportionate for this type of case. It also includes things like that are in your temporary files, like your RAM or cache memory, other things like internet history, things that really, the odds of there being anything really significant in there that's not duplicative of your active files is just not worth it. Legacy systems where you can't get at data anymore. If you can get an agreement up front, you don't have to deal with that, all the better. And if not, then you've got to fight. You can go to the court early on and get this addressed. So Office 365 or Microsoft 365 content, I've started seeing this be put in to some protocols, really, at least that if you're going to use, a lot of businesses now have Microsoft 365 and its e-discovery component. Purview is the sort of current name for it. And one option that companies will use is, if you're going to use search terms, that I'm going to run search terms through Microsoft 365 and then only give to my law firm or to the vendor who's handling the ESI just the search term hit documents and their families. There's some debate out there among that how effective that is, and should you instead collect all of the email for your relevant custodians and then let the ESI vendor, who have more robust search engines than the Microsoft 365, if you're going to weed things out. I think there's a real proportionality concern of doing that, because the cost of ingesting all of their email, as opposed to the ones that you're going to run search terms on anyway, how much are you missing? How important is the stuff you're missing? Those are all things that you want to consider, so that you're not in hindsight. There was a decision that a special master put out in a case faulting the party for using Microsoft 365 to run their search terms, and required them to go back and re-ingest all the key custodians into their document review system instead of relying on the search capabilities. The special master also happened to work at a vendor that supplied that type of services. I'll leave it to you to decide how appropriate that was. Hyperlinked documents, addressing those, and we'll talk about this a lot more, and this will be part of the modern attachments, but you can have things in there, either well done or well not, that talk about how do you handle hyperlinked documents. There are some protocols out there that will say, if you have an email that just has a link to another system where that document is found, there are some protocols that will tell you, oh, you need to treat that like it's an attachment. And we'll talk about that more later on, but those are things that you should be worried about.
Doug, we have a question. Doug, can I interrupt?
Sure.
We have a question. Are you going to talk about how AI changes the calculus you just commented on?
So I think we're going to address the AI as much in the review. There are aspects of what we're going to talk about as a category of how are you going to do your identifying your review population. And I think that's where we're really going to address the AI. I think that's probably a better place than it's sort of on the initial preservation, because I've not used AI very much at this stage.
I'm not sure that because of where the question came in, it might be helpful if whoever submitted that kind of fleshed out their question just a bit to let us know which calculus it is that they're looking at.
There's a follow-up question by the same person. Doesn't AI make it less expensive?
No, not right now. We can talk about that a little bit more when we get to it. But
because there's always a charge for ingesting all of the information into your system, and maybe on a per gigabyte charge. And so the more you have to bring in before you start using AI and search terms or whatever, there's an upfront cost to that. So a lot of times you'll combine maybe search terms and AI where you can, if in the appropriate case. Sometimes you need to do that, other times you don't.
I want to set like a background rule for when we use the term AI today, because AI can mean a lot of things and does mean a lot of things, including machine learning technologies that we've been using for years in e-discovery. So AI in the modern context, discussion wise, is typically meant to refer to generative AI. So if I say AI today, I mean generative AI, because otherwise I'm going to specify what it is that I'm talking about.
Perfect. The additional comments from the same person just say proportionality and then versus the cost of human reviewers.
Okay, so that's a question for
the review part.
Great, thank you.
But just briefly on the preservation collection piece, there's usually sections there. How do you deal with hard copies? There are things about other apps, whether it be your chat apps, sometimes there's more modern apps like Jira and Confluence are two proprietary apps where businesses store information, where there's particular challenges in getting things out of there. And so a lot of times those are discussed in terms, it may be even if you have one of these, we will meet and confer as to how to deal with it. But it's something that a lot of times is covered in these protocols, as well as things like how are you going to deal with text messages, data information on your mobile devices.
So processing and filtering, these are things that are when your data set has been collected, whatever it's going to be, how is it going to be processed to make sure everyone is on the same page with things like what time zone will be used. That can make a big difference when you start building chronologies, both sides, both ways. What file types aren't going to be produced for various reasons. They don't have much, if any, probative value to the case, perhaps. How documents will be deduplicated, and if they will be deduplicated in some instances, and what to do about password protected files and similar types of technical challenges that will be encountered as documents are processed. So this is the step between collection and review, essentially, or analysis. This is really, most of these points have become rather standardized. So you're probably going to be looking back at, well, you're going to be talking to your vendor, first of all, if you're using a vendor, to make sure that you're incorporating the provisions that they can comply with, or that they recommend. But these are things that you can mostly dust off from your last version of the protocol. I wanted to quickly hit on this idea of proportionality, because Doug's mentioned it a few times, and it is something that we lose sight of. Proportionality, it is well established now that proportionality does apply to preservation, in addition to these steps that we're talking about here, with one caveat, and that is, according to at least some courts, proportionality applies until you reach an agreement, and then at that point, the agreement trumps proportionality. I don't agree with that outcome, but it is out there, and I want you to be aware of it. That's the other reason to make sure that you're really letting proportionality guide you as throughout this process so that it's built in. So one of the questions, or the question that was just asked, was about the next stage. So not preservation, but rather review. Review is going to be probably part of your ESI protocol for most of your larger cases, at least, or larger data cases. In that, the ESI protocol is where you should reach agreement on search methodology if search terms are going to be used, on whether or under what circumstances and how TAR may be used. So technology assisted review, what was called predictive coding, computer assisted learning, all of those things. There are validation concerns that pop up under both of those. When they're talking about search terms or TAR, you're going to have a need to reach agreement on how the efficacy of those terms is being, or of either technology is being judged. And this is an area that we could spend days talking about, because validation is maybe the most disputed area when you're talking about ESI protocols in larger cases. Validation can be very time consuming, and it is an area where you absolutely must involve the vendor, if you have a vendor who will be assisting with that step, deciding on how much you're going to share with the other side, what needs to be shared with the other side in terms of disclosing efforts made, or percentages of the various stats that help to determine how effective and efficient a search is, or a tool that's assisting is. So that's, like I said, you need to have a really good handle on your data, including the size of your data, and know what kind of tools you want to use. Now, let me distinguish though, you do not have to disclose nor agree to using TAR or any other tool to help you make your review more efficient. What this is contemplating, and you can say that straight out in the TAR protocol, I do. When there is this type of agreement that needs to be reached on methodologies and validation, it is when you are culling documents from consideration, not when you're prioritizing documents for, what will be reviewed first, not when you're deciding, how it will be batched out if you have if you're working with a room full of review attorneys. Those decisions, using these tools for those decisions, don't need to be incorporated into your TAR protocol. Email threading, that is, I did not expect that to be an issue that would be that there would be any debate about, honestly, with TAR protocols, but there's a lot of back and forth, or there can be a lot of back and forth about how email threading will be used in terms of production. So will you be able to withhold any portions of threads if the more inclusive portions being produced? That's an issue. If it's going to be an issue, get it figured out at the ESI protocol stage. And that will also have an impact on your privilege logging discussions, most likely. So if privilege logging is being dealt with in the context of your ESI protocol, great. If not, make sure you're having that discussion and considering those issues in both contexts.
Can we go back for a second, Angela, because there's a couple of thoughts I want to throw in there.
Sure.
So on the identifying the review population, this is one of an area where there can be a wide divergency of views, and maybe the one where you're going to spend the most negotiation, because there's one school of thought that says, look, I get to use my reasonable search methodology if I'm the producing party. And you really only should have a say in it if you can identify a problem. Maybe I'll disclose what search terms I'm using. A lot of times you'll agree to take into the other side's search terms as a default. How am I going to validate? There are protocols out there that where a court has issued a ruling saying that if you use search terms, for instance, that you have to do sampling of the documents that were non-search term hits. And with TAR, it can be as minimal disclosure of we're using TAR, here's the tool we're using, to people wanting to know, people urging that you be required to disclose sort of if you're using statistical basis for when you're going to cut off review, or how are you using it to cull, at what specific level are you doing that? And there's all sorts of differences of opinion on there. So that's one area where there's could be a lot of negotiation. And on the threading, I always think it can be really advantageous if you're the producing party to some extent, that I only have to review the last email in a unique thread. On the other hand, if you're receiving it and you like being able to easily search the metadata for every email sent by a person, well, if all you're getting is that last email in the chain, you're going to not come up in the to field or the from field with all the emails going up forward there. So there's a lot of pros and cons in doing that. And I think the key points there, you want to make sure that you're getting what you want and balance that against, all right, how efficient can I be if I'm only producing, can I really save on my efficiency by only producing the most recent unique thread?
I'm just going to put a little more color, Doug, on the tension you mentioned between this this philosophy that I should be able to basically do what I want. And if there's a red flag that's raised at that point, we will deal with it, versus like the very extreme other side, which is everything should be disclosed to the other side, including in some instances, null documents that don't hit on search terms right when you're testing that. So there's a lot of ground in between, and I think there's this the Sedona Principle 6. Many of you are probably familiar with this idea that the responding party is the one best situated to evaluate kind of the procedures and methodologies, tools that are going to be used to preserve and produce its own data. So that there was a time when that was kind of like, that was it, that's the answer. Courts are less, it is less the ultimate answer now, other than the tools portion of that, which I think is still very much something the courts aren't going to require you to use a tool that that you don't want to use, basically, if you select a different reason. But that has to be balanced against the what happens if you do go that route, which is the courts are saying if you don't have this agreement up front about how you're going to, about your methodologies, about how you're going to do these things, and then you're going to have to answer some questions about it, right? You might have a 30B6 that's specific to these issues. You might have discovery about discovery that you can otherwise avoid. So that's kind of the balance, is you want to find the point where you are disclosing enough that the parties can agree, but that it does not turn into a micromanagement situation, because then you will be doing validation for years before you even get to your actual review. But doing that so that there isn't an argument for discovery about discovery unless that red flag later pops up. So that's just
I agree that the two extreme positions of I'm not going to tell you anything unless there's a problem, or we've seen some of the early TAR protocols back when you would kind of use one method of TAR is you're going to do a seed set, a training set that's used, where they agreed to disclose all the documents that were in that, whether they were coded responsive or non-responsive. And that turned out to be a giant disaster. So I don't think those extreme positions aren't going to get you much these days. And it usually ends up somewhere in the middle then.
Agreed. Doug, you want to talk a little bit about, we talked about the specs, right? The document production format and that will, I mean, that sometimes appears in your discovery request too, right? But it should definitely be in your ESI protocols. You want to hit on some of those issues?
Right. And this is sometimes what people, if they're doing an ESI protocol, this is the one thing they'll be able to put in. Sometimes all those other things don't get in there. Usually the production format does. As Angela referred to, you could follow the rules, which allow for the requesting party to specify the format they wanted in, then allow the responding party to object to that and state what they're going to do. Or you can basically negotiate that up front as part of the ESI protocol. What you really don't want to do is, and I'm sure that this has happened with Angela, where I get called in on a matter I'm not involved in. Oh, we're having this formatting issue. I said, well, what did they request? Well, they didn't make a request. Well, what did we say we would do in our response? Well, we didn't do that. Is there a protocol? No. All right, then we're back to sort of what's reasonable is the standard. So you're better off to avoid any disputes down the road to try and agree up front. And I think the general principle that should apply to your production format is you don't want to downgrade the information that if you were able to get everything in live and native and it's like for email, if I can sort my email, I can search my email, I can sort it by from or to or date, that kind of thing. You don't want to have downgraded the information that's in there if it's going to be important. That kind of is the overarching theme of what the production format is all about. So some typical ones are, you got to preserve your family relationship. If I've got a document and it has attachments, I need to be able to produce them in a way that the receiving party can tell with what attachment goes with what email. I'm going to give you a giant one big PDF of all the documents. That doesn't usually work very well. I'd be wary of that because it's very difficult if you do that to actually understand what's there. The be cautious with hyperlinks is the idea that we mentioned before, and will be covered a whole lot in the next session of this, is that, I'm producing something that has a link. I'm producing a Teams chat that in it, there's a link to a document. Well, do I have to, some protocols will require you to produce that document as an attachment. A lot of times that's impossible to do, or you're going to have to go back and hindsight and do it. And frankly, with Microsoft Teams, it's really confusing because if Teams extracts it, it'll extract the version of that document that exists at the time you're collecting, not at the time that the text was sent. So be cautious of anything requiring you to provide information about the family relationships of the documents that are on the end of.
I'm just going to break in, Doug, because I do want just like, please have this on your radar that this language can sneak into this area that is otherwise just about your production format, defining what a family is. You can't just accept any language. You must read it all through because this is where it's at. If it talks about embedded information or linked information, make sure you're reading it carefully to understand what it means. Talk to your vendor and make sure that whatever that definition is there, it's one that you can comply with.
Angela, Doug, I have a question in the Q&A.
Sure.
When structured data is required to be collected and produced, would you include procedures in the ESI protocol or have a separate structured data agreement in place? I've seen it done both ways.
Yeah, I've seen it done both ways also. And to me, it kind of depends on, I don't think it matters. Honestly, to me, it's like a TAR protocol. You can have a separate TAR protocol. You can build it into your ESI protocol. You're typically not going to be in a position to do all of it at once, though. So you're going to do it just in order to get things moving. You're going to do them separately.
That's what I was going to say. Is
yeah.
that if you're doing this early on in the case, you might not even have the document request yet. What particular databases you are going to retrieve this data from could have a drastic effect on what your procedure was. So most of the time I've seen structured data provisions in an ESI protocol. It's if you're going to produce structured data, we're going to meet and confer about it beforehand. And that's the safe spot for most of this. And you'll see sort of at the bottom of our list of it's that promise to meet and confer is the way to kick the can down the road. And then to be able to deal with different things, they may require different solutions depending on what the issue is. And if you're trying to get an ESI protocol up front, you don't want to, the other theme of this whole thing is that you don't want to agree to things that you can't do. That's really the overarching principle of your production format, as much as no downgrading, is you either know how you're going to do it, you're going to agree to it that I can do this, or you're going to kick it down the road and agree to meet on confer on it. Just quickly, like some of the pitfalls that I've seen, color images. A lot of times the first draft of a protocol will be, you'll produce in black and white, except you have to produce in color where the color is necessary to interpret the document. Well, to do that, your document reviewers are going to have to evaluate every document for whether the color is necessary or not. And I always usually push back on that if I've got a sizable production where I've got my reviewers have enough on their mind to get whether it's responsive or not and whether it might be privileged. I try to shift the burden then to say, we're going to produce everything in black and white. And if you think you need color on anything, just let us know and we'll be reasonable and we'll confer about it. But we'll produce it on a case-by-case basis, not having to make that call up front.
That's one of those situations I'll just call out where if you're dusting off an older ESI protocol here, color images may have been an issue in the past for you. If you're using a different tool now for review and production, it may no longer be an issue just because of how some of these tools produce in color makes no financial difference. So no real difference. It depends. So that's one of those instances where talk to your vendor, find out if it's truly an issue, or if you're using an in-house tool, just do a little bit of exploring to find out if that's even an issue you need to fight about. It may not be any longer where it was almost uniformly several years back.
True. Or if you're never dealing with hard copies, it could be a big issue. We had a case where, without discussing it with anyone, the person gave the instructions to the printer to do everything in color, and it like multiplied the cost of this thing by about 8 times. So that was an issue. One of the interesting big picture category in production format is, are you going to produce in native, or are you going to produce in images? And I think everybody kind of agrees that the email themselves usually get produced in some sort of an image, or but not in its native MSG format. And I think most people will acknowledge that if I'm producing Excel spreadsheets, and I think PowerPoints and other presentations really belong in this category, as well as they're better produced native, because reducing them to print can really make them almost impossible to use, or you're going to miss a lot of the content unless you do it right. There are some that will argue that you need to produce every attachment in its native format because it's easier to handle. And the big dilemma then is, if you're producing things natively, there's not a bait stamp burned into the document. And then when it comes to depositions, you've got to have a way of then having some sort of Bates number identifier on the document, or at least in the name of the file. But
I just want to add to that, you also don't have a confidentiality designation burned in, which sometimes can be very critical.
Right. You can have that in the name of the file, but that somebody's printed out and done something with it afterward, none of that shows up. So, how you're going to handle extracted text versus OCR with, if you really want the extracted text, unless there's been redaction where you can use the OCR, or if there isn't extracted text, those issues are usually covered. The metadata, what metadata fields am I going to produce? I want a load file in most cases. You're going to want a metadata file so that you can make that file usable. If I just print out all my emails to PDFs, you lose all that ability to sort. Even if you can search them, you can't search by date, things like that you really want the metadata. And what metadata fields you want and agree to produce, this is where it's also critical that you make sure that your system can actually provide that metadata field. And a lot of times, if you may agree to a certain metadata field, you need to make sure that you've collected in a way that's consistent with that. A lot of the
I have a
metadata-
comment.
Sure.
And it's back up to native versus images, I believe. It just says native issue, produce images for the deposition. If that's something that
It's
either of you would
done-
like to comment on.
Sure, that's one way of handling it. So if I've got an Excel spreadsheet and it's produced native to me, and if it has only a few columns, I can print it out, it'll work. And at that point, I can give it a Bates number. I can do a slip sheet with the Bates number and attach it to it. You could generate a page by page Bates number, some ways to do that just for the depositions. There are ways to do that. It's just a matter of, are you going to do that on a case by case basis, or do I really want everything in all native, where most of the time that's more of a hassle to do. There's workarounds either way. It's just a sort of the cost benefit analysis.
That particular compromise also, though, it also does not always end up being a compromise, and both sides end up being rather unhappy when they're having to disclose what exhibits they intend to use at a deposition in advance so that they can get the other side to provide them with Bates.
And lawyers always have all their exhibits lined up for their depositions, 3 days beforehand, so that they can do getting the images made and all that, because lawyers never do things at the last minute. That's usually where, and if am I going to ship them to my deposition? You got to build that in there. I agree that a lot of times people say, I want the native, and we'll just do the images later on. You end up regretting it.
I think
one
too,
case where it said all native, and apparently cost was not a factor because everyone just started producing both.
when you're talking, especially for some smaller cases, where maybe cases that opposing is on the not as sophisticated when it comes to ESI in general, make sure you're talking about the same thing when you're talking about natives, because it means something different to some people. I have inherited cases where the agreement was native, and what that meant to them was it was going without a load file or anything. It was just going to be, I'm going to right click and copy all these MSG files, and boom, there you go. Okay, that's not what I think of for a native production. So let's make sure we're all on the same page with terminology.
There's a few comments to follow that first one, and the second comment was produce both native, which costs near zero, and images. And then it says, if you do not produce native of Word documents, how do you handle track changes? Which also is followed by, my comment regarding native and images is for all documents. Native costs near zero.
No, well, but there are other reasons that you would not do natives, and the fact that they're out there without the Bates stamps and without the confidentiality or highly confidential or AEO designations is one of them. I will say that for some cases that may be appropriate, I will tell you that for large trade secret or other cases, where there's a source code or anything along those lines, it will not be agreed to by the parties.
And I think
and most of the time, I have not encountered a judge who has not been sympathetic to those concerns in those circumstances, and who, once we are able to show them that we're piecing together and for function, they will be getting what is equivalent to a native, right? If we're doing this with a standard load filing with the metadata that's been agreed to and with the text that's been agreed to, what they're getting is functionally the same as a native from their perspective once they piece it back together in their tool. So judges tend to understand that. There's a lot of good Sedona Conference information you can use to back that up in cases citing those. So I understand the push to go native, but there's going to, and Craig Ball, I'll mention Craig. He has some great ESI protocol resources out there available to people, and he is a big proponent of native productions. It is one area where many of us in the field disagree with him, even though we think he's wonderful and,
Mhm.
and well, we think he's wonderful in all regards, but that's one area where we will
Mhm.
respectfully disagree. And so far, courts have been sympathetic to that as long as it's not a situation where it's going to hold up discovery.
Well, thank you. A few more comments and then I'll let you move on. It says native being a load file is like saying metadata is a dance. And then they put, yeah, it's because of this, the reason we want native. And then it says trade secrets. That's what a confidentiality agreement is for. And then the last
This
comment
is
is not so for things like track changes. So I'll
No, track
leave it at
changes
that.
is usually, so I will say this, track changes is usually agreed to in the in the ESI protocol, how those will be processed. And it could be that those are produced in native because there will always be some documents produced in native that are called out. So the other comments, that's advocacy. That's not really what we're here to talk about today. Take that to your negotiations if you wish. We're just letting you know what to keep on your radar in terms of what's going to be there. We're going to move really fast here because we're at 1:53. But other things to consider adding in fact, I would say don't consider it, do it. Make sure that you're building in that the agreement can be modified, that the parties are doing their best with the knowledge they have, but as you get in there, things are undoubtedly going to just change. The parties don't intend to waive proportionality. It's an escape valve basically to make sure that you aren't later stuck with something that you agreed to in good faith, believing it could be done, but find out that it's not as simple as it seemed up front. The question of whether your ESI protocol should be an agreement or an order. I have had judges who will not enter it as an order. They will only enter the disputed provisions or guidance on the disputed provisions for the reason I just mentioned. They are cognizant of the fact that these are very technical agreements, and often the parties and the attorneys are relying on information from vendors and they don't want to turn that into an order. Rather, it should be an agreement guiding the parties, come back if there's a problem. The potential broader scope, protective orders, clawbacks, privilege logs. I really don't feel those should be personally encompassed in an ESI protocol. I will say this, if you're going to do a clawback though, especially 502D, make sure that you are doing it in an order. So if you intend to combine it with your ESI protocol and leave it as an agreement, you will have trouble if you need to later rely on that. So don't get it in the form of an order. Customize, as you've kind of picked up. I think, a lot of this depends on what you have and what you need from the other side in terms of volume, in terms of data sources and types. So don't ever just, I see this call come across in various industry groups. Hey, does anyone have like a boilerplate ESI protocol? It's like, no, I can give you a starting point ESI protocol, right? Or I can direct you to eDiscovery Assistant with their great guide that they've got, or Craig Ball and his resources to consider the things. But that's what it is. Those are to make sure you don't forget to think about something. They don't stand in place of actually customizing the agreement that you're going to use in your case. I want to very quickly talk about some of the modern issues to consider. And again, these will be, that is the subject of an upcoming session, modern issues that are impacting ESI protocols. We've hit on this a couple of times, hyperlinked documents inside in an email or elsewise. Should they be treated as attachments? Of course, there are two different, there are internal links to internal documents. There are links to external sources. So as an initial matter, I say, make sure you know what you're talking about in terms of those, and you're distinguishing if you're going to address this in your ESI protocol at all. You'll hear the term modern attachments. I don't use that because I don't agree that they're attachments. You can agree to treat them that way if you would like to, but with the understanding that there is some significant risk involved with that, but that doesn't make them so, in my opinion. I'm going to point out a couple of cases here and note that there will be a resource for attendees, a web page later where we will gather some resources together that you'll be able to access. These slides with links to the documents will be a part of that. The links are to eDiscovery Assistant, who has been kind enough to provide the attendees with that. So a lot of these are unpublished opinions, but you can pick them up through the links that eDiscovery Assistant has been kind enough to sponsor for us. So just very quickly, I'll walk through. Nichols v. Noom is kind of the granddaddy, even though it's not very old, case in terms of whether a hyperlink inside an email is an attachment or not. The answer, according to the judge there, is it's not. The parties had not agreed in that case that they would treat them as such, so they were operating from a blank slate, which was important to how that case came out. And how that case came out is parties didn't agree, so there. But you know, kind of a practical solution that the judge implemented is if there are instances where something, it's critical, it's a critical document, you can tell, then the parties should be willing to meet and confer and work together to try to locate those particular documents if they still exist in that location. StubHub's different in that there was an agreement, so that I'm not going to walk through all of these because we're now at 158. So just understand that these are, you do read these cases because all of the considerations are there. All of the problems with agreeing to this are there, or at least problems if you don't know what you're doing. Use and disclosure of generative AI. If I'm going to produce my documents and the other side is going to use generative AI on them, I want to have it in writing that you know, in the agreement, or I've actually been putting this in the protective order, but what can and can't, what can and can't be done. So if it's going to be put into a tool where there are bumpers in place that respect privacy and security, then that's fine. Otherwise, it's a no. And that's, again, something that we'll talk about in another session. But just be aware that that is something you should be considering now in terms of should it appear in your protocols. So this is so easy when you get negotiating an ESI protocol to lose sight of the practical solutions, the easy things. You should always be taking a step back to look at it from that approach so that you don't lose sight of the true goal. You know, winning the negotiation really means that you are winning from a proportionality and a standpoint, not that you're winning every dispute. So keep that in mind as you're going through. We've got 1 minute. Again, these links will be provided to you courtesy of eDiscovery Assistant, but going back to 2009 is the you know, the I agreed to what, that's the case that has been giving us nightmares on that point since 2009. Once you agree to something, then you are stuck with it, even if it takes you $6 million to comply, according to the judge in Fannie Mae.
And I think the two key takeaways for that are, one, try not to agree to things unless you know you can do them.
That's right.
And B, like Angela said earlier, always build an escape clause in whatever you agree to, that if it turns out this is going to be unduly burdensome and disproportionate, we're not waiving any right to go do it. Because that case was well, you agreed.
That's right.
And therefore, proportionality is out the window, which is really nonsensical, but that's what the court held.
It is. And several of these other cases kind of come to that same conclusion, even if they don't use the term proportionality, just your agreement governs. So do be careful, of course, in every instance. Let's see, we got, yeah, McCormick, you know, if you, in that instance, there was an agreement that the documents would be reviewed, search hits would be reviewed, and the court held them to that, again, despite what I would view as proportionality issues with that decision. Carl Zeiss deals with making sure, in my opinion, the takeaway is make sure that you are talking with your vendors throughout and that you are very aware of what is happening and what you're agreeing to and that it's actually being done. In that case, true attachments were not processed as they should have been and included as they should have been. And the judge made them go back and redo things. And it was extremely costly, for a costly mistake, a costly error. So be aware of that when you're there. Ray Skanska, so there's this is again really hitting on, not only is it important to know what you're agreeing to, but make sure that you are tying what you agree to what you are able to do and what you have done at the preservation stage. In this case, there was an agreement to produce some texts, and as it turns out, those have not been preserved. So there's that was not a happy day for those attorneys. And we'll leave you with this, although I'm happy to stick around for some more Q&A if anyone wants to, and maybe we can talk Doug into it as well. But, you know, it really boils down to this. This is that StubHub refund litigation that I referenced earlier with the issue of hyperlinks. But, you know, the judge says, let's get back to basics. Litigants should figure out what they are able to do before they enter into agreement to do something. And that is the takeaway I would like to leave you with today. Please know what you are agreeing to before you agree to it. Doug, any last words from you?
No, I think we covered it. I'm happy to stay on though, if people want to talk further.
Well, thank you, both of you. This was really interesting. I'm impressed that we got through it in almost the allotted time. For anybody who has to drop off, I will follow up and provide the slides. I got several questions regarding the slides. And as Angela mentioned, we'll have embedded links to the cases courtesy of eDiscovery Assistant. I will also probably follow up in the near future once I get some confirmation regarding any status on CLE. And you will hear from us regarding the next 3 sessions in this series. So thanks again. Anybody who wants to stick around, I'm going to leave the floor open, but I just wanted to thank everybody from all of the Midwest chapters and Angela and Doug in particular.
Yeah.
And just so you guys know, in the Q&A, you're getting lots of kudos.
Oh, great. We like those. Keep them coming. Excuse me. I have I've been very sick actually for most of the month, and I have vertigo on top of that. So I was happy to make it through without falling off my chair. I told my husband this morning that Doug might have to you know, step in and do more than he'd anticipated if I suddenly fell off the screen.
I was just
I'm
hoping you
pretty
were gonna be
impressed,
too mad.
actually. Sorry, Doug, go ahead.
I was saying I was hoping that Angela wasn't going to be too mad at me, as she's a Michigan State grad and I'm an Ohio State grad, after our basketball game last weekend.
Oh, no. It's U of M that has the big problem with you guys.
That is true.
Are there questions coming in, Abby, or should we go ahead and
Just a lot of kudos and great jobs.
All right. Well, you know, I'm available online if anyone wants to send me an email with a question. I'm always happy to follow up, and I'll volunteer Doug for the same. Excuse me.
And me as well. So as I will be following up with attendees anyway, if you have any questions that you want me to send over to Angela or Doug, please feel free. Thank you, guys. This is great. This is really interesting.
Thanks, everybody.
You sound surprised.
Never, no. Never. All right. Well, thank you. And Angela, feel better?
Thank you.
Yeah, thank you guys for doing that. Great job.
All right. Thanks much.